And then they died is usually part of any good what's the worst that could happen scenario, just FYI, although it is true that and then they didn't die, but they needed care for the rest of their lives is actually more expensive. And yes, I know that's ghoulish. Sorry. Happy November. We are heading into one of the busiest times of the year for people in insurance, so I want to thank you for taking the time out of your very busy day to listen for those of you in the industry. I'm Meredith Brasher, a former underwriter turned historian, and this is Insurance versus History, the podcast for people who want to understand how insurance works and why insurance matters. I tell stories about historical events and modern-day ones and how insurance was involved. You will be smarter after you listen, I promise. Today's episode started out as an idea for a short rundown of 23andMe's various insurance issues, but there was just too much fun stuff to talk about, so it's become a longer episode. You probably know what 23andMe is, but if not, this company is the best-known direct-to-consumer DNA and genetic testing company in the U.S. and probably the world. Something like 1 in 5 Americans has submitted their DNA to either 23andMe or another company that does the same thing. As of 2025, only 2 other entities have more information on human DNA than 23andMe: Ancestry.com and the Chinese government. I didn't know that before I went into researching 23andMe, and I'm not going to lie. I have spent a lot of time thinking about the implications of the Chinese government holding all that genetic data on its citizens. 23andMe filed for Chapter 11 bankruptcy in March of 2025, and at that time there was a flurry of news stories about it, but that's since dropped off. I think it's a great time to go back and figure out what was going on and how insurance was involved, and what all this DNA info means for you, the individual, even if you never submitted your DNA to one of these companies. It's also a great introduction, albeit very gently, into the painfully complicated topic of health insurance in the United States, which is something I really have never spoken about on the pod, but I am easing myself into talking more about health insurance later on this season. Before I get started, if you like the podcast and you find it valuable, please take a few seconds to rate and review the podcast on your podcast player of choice. If you aren't already subscribed to the pod, please do that too. If you'd like to support the development of more episodes, please consider donating to my Buy Me a Coffee fund at buymeacoffee.com/InsuranceVSHIST. That money goes right back into the cost of producing the podcast. Even better, you can hire me to come speak to your organization or meeting about the history of insurance and why insurance matters. You can also connect with me via LinkedIn or email me directly at meredith@insurancevshistory.com. There are a couple of insurance terms you should know to better understand this episode, but lucky for you, most of the confusing stuff is not actually insurance stuff. The main thing I want to talk about briefly is how you insure a company like this. Now remember, when this company started, it was 2007, which was almost 20 years ago. Wow. There are some insurance products now that didn't quite exist in 2007. As a broker or agent, you need to figure out what types of insurance are necessary to protect 23andMe in the event of some kind of claim or lawsuit. Some insurance is obvious. The directors and officers are going to need coverage through directors and officers liability. The buildings and the contents need coverage through property, etc. But this isn't like a consumer product company like, say, Lego. And neither is it a healthcare company like a hospital or a pharmaceutical manufacturer, though it is true they were trying to get into both of those types of things through the telehealth company they bought called Lemonade and through a pharma development arm they started later on. 23andMe is, in essence, a tech company, but also a medical company. and the customers are consumers, not medical providers. But the medical product they provide isn't a medicine or a device, it's information. So it's a bit complicated. I know a little bit about how they structured their insurance back in 2007, but a lot of this is conjecture. And I would encourage anyone who knows more about this to comment on my LinkedIn about it because I would love to hear it. For a risk like this, the first thing we start with is what is the worst that could happen? That's where most underwriters start, by the way. Well, first, you're handling people's sensitive information, including medical information. How that information is shared and who can access it could be a problem. And the worst thing there is that you could have that information used against you in some way. That data is stored on a computer and transmitted through the internet, so if that data were accidentally or intentionally released, that could also mean you might be harmed in some way. Some of that data deals with life or death issues, and if it's inaccurate, it could result in people taking steps they would not have taken otherwise that cannot be reversed. Worst that could happen? I think it's a situation where someone has surgery as a result of this data and it turns out to be wrong. Or even worse, they didn't take a particular medical step because the data they received said they weren't going to get a disease, and in fact, they had that disease and then died. And then they died is usually part of any good what's the worst that could happen scenario, just FYI, although it is true that and then they didn't die but they needed care for the rest of their lives is actually more expensive. And yes, I know that's ghoulish. Sorry. None of the scenarios above, if they involved a handful of people, would really add up to a lot of potential insurance payout, but if a bunch of people, if a lot of people, if a, say, class action size of people were affected, then that's when you start to worry about the cost when you're a big insurance company. What is 23andMe's product? Well, the test is the product, but the actual physical test is probably not going to cause some major issues by being used unless those tests were all contaminated with something. But the real product is the result of the test, which isn't really a product by the insurance definition of the word. What 23andMe are really offering is a professional service, like a doctor or a psychiatrist or a lawyer, giving you information based on the test they interpret. It's not medical malpractice if they're wrong, so that's not quite the right thing. 23andMe would want to make sure that in the event they gave someone wrong information, they would be covered in the case of a lawsuit. In 2007, that meant buying a professional liability policy, which is a kind of policy that covers errors and omissions in performing professional services. The policy wasn't exactly what they needed, probably, but it was available. While other companies had been doing genetic testing, the fact that these tests were being purchased by consumers and not because a doctor had ordered them meant the company was just different enough that the insurance industry was maybe not entirely prepared for exactly the risks that this company had. As the famous Margaret Atwood quote goes, which I am sure I am quoting incorrectly, new technology usually does three things: the thing you expect, the thing you don't expect, and the stupid thing no one ever considered. The other thing that 23andMe needed was something called cyber liability. If ever there was a sexy area of insurance, right now cyber liability is that sexy area. In 2007, cyber liability existed, but it really was starting to ramp up just about then. Cyber liability is insurance that primarily covers a data breach of that company's information about customers. I mean, you've probably been part of a data breach, and you've gotten emails telling you about it and offering you free data monitoring for a certain period of time, right? That's exactly what cyber liability insurance does. And those costs to the company can be very expensive, so you want to have some insurance to cover that. Plus, there are a lot of rules and regulations about how you're supposed to handle a data breach, and by buying cyber liability insurance, the insurance company can help you navigate all of those issues successfully. It can cover a lot of other related things, the big one being cyber ransom, and it covers a lot of stuff today that it didn't cover in 2007, but Typically, data breach losses drive claims for cyber liability policies, and it's the main thing that they worry about. That's probably more info than you needed, but whatever. As always, in the fight between insurance and history, there's always a winner and a loser. My guess here is that insurance will win, but it might be a hollow victory and not good for us as human beings who use healthcare services. But we'll see. Let's get started. 23andMe started as a company with 3 co-founders, Anne Wojcicki, Linda Avi, and Paul Kusenza, in 2006. Now, I had heard the name Wojcicki, but not Avi and Kusenza, even though a deep dive into the origin story suggests that Avi, a serial entrepreneur and tech startup vet with a BA in biology, and Paul Kusenza, a Harvard MBA, were really the ones who came up with the idea. Kusenza worked at a company that specialized in whole genome association studies, though he wasn't a scientist, and Avi had worked for him at one time. But to read articles about 23andMe, well, it's all about Wojcicki. Wojcicki, who likes to make a big deal of her Yale bachelor's degree in biology and typically downplays she worked as a biotech analyst at a hedge fund that folded called Passport Capital, okay, whatever. She met these 2 people because of her boyfriend, eventually husband and eventually ex-husband, who you probably do know, Sergey Brin. Brin is one of Google's founders, and he'd met Avi, one of the founders of 23andMe, through Michael J. Fox's Parkinson's Research Foundation. Wojcicki wasn't just connected to Silicon Valley through her relationship with Brin, though. Her sister was CEO of YouTube and one of Google's original employees, employee number 16, and her father was a professor of physics at Stanford. If you didn't know this, Stanford is ground zero both for the development of modern computing and for the development of much of today's Silicon Valley. This meant that Wojcicki was dead center positioned in the tech boom, and I guess I'd be surprised if she hadn't done something big like start her own company or start her own company with other people and then take all the credit. Your pick. If actors' kids are Nepo babies, I'm not sure what this is, but it's something. She might be really smart. I mean, she did go to Yale. She had more education than college dropout Elizabeth Holmes, a contemporary medical tech founder in the same time period. But she wasn't exactly a specialist in genome research or lab technology. With all those Google connections, the company these 3 founded, 23andMe, got an early financial boost, a $3.9 million investment from Google to get up and running. Just to put this into perspective, Elizabeth Holmes started Theranos in 2003, and in 2006, when 23andMe started, Theranos was a very sexy investment. So even though they did different things, I suspect the supposed success of Theranos was also a boost for 23andMe. Theranos did direct-to-consumer blood testing for disease. 23andMe was focused on this direct-to-consumer pipeline, but for DNA testing via saliva, to provide ancestry details and details on specific markers for diseases like breast cancer, Alzheimer's, and Parkinson's. Their stated goal was to, quote, aggregate the world's genetic data, unquote, with a loftier goal to use that information to produce their own medications and help to cure disease. Their stated goal was not to help people understand their health better. And I think that's an important thing to point out. The business itself was never about the consumer. Now, these were not new tests, unlike what Theranos wanted to do. What was different was the pricing and the fact you could buy these tests as a consumer directly. Genome testing already existed. You had to have a doctor order it for you. It was often quite expensive, and after you received the results, you were required to have genetic counseling. Genetic counseling was never part of 23andMe. Once you got the results, you were on your own. You can see that might be an issue if you get a test back saying you have markers for diseases like breast cancer, Alzheimer's, or Parkinson's. I'm not comparing Theranos to 23andMe because I think 23andMe is fraudulent. But I do mention it as these were 2 tech companies founded to provide some kind of health service. And I do think that Theranos and Elizabeth Holmes, before they were exposed as total frauds, that they raised the profile of medical tech companies in Silicon Valley and made them especially interesting to investors in a way they hadn't been before. I'm just saying. 23andMe started offering testing to consumers in 2007, testing for about 90 different things. The same year that Wohicki married Sergey Brin on the beach on an island owned by David Copperfield. In 2008, 23andMe was Time's Invention of the Year, even though it wasn't really an invention. That same year, the U.S. government enacted something called GINA, which is the Genetic Information Non-Disclosure Act. This act restricts what can be done with your genetic data and how health insurance companies can use that data. There are some giant loopholes with this act, which I'll come back to later. By this time, both Linda Avi and Paul Kusenza had left the company, and the reasons for those departures seemed innocent enough, but I have to wonder. Either way, it was all Wohicki's show now. As you might expect, 23andMe continued to refine their offerings and prices. Other companies entered the market, but 23andMe seemed to have the best marketing. It's certainly the only company I knew of, and they started selling tests on Amazon.com in 2010, which was a big boost. But that same year, the FDA started making noises that these direct-to-consumer saliva testing kits were technically medical devices, and they needed FDA approval, which 23andMe did not have. Although 23andMe did try to get approval from the FDA after 2010, in November 2013, the FDA issued a letter to 23andMe which analysts called, quote, one of the angriest letters ever sent to a private company, unquote. I do love an angry letter, so let me quote some of the better parts. The Food and Drug Administration is sending you this letter because you are marketing the 23andMe Saliva Collection Kit and Personal Genome Service without marketing clearance or approval in violation of the Federal Food, Drug, and Cosmetic Act. Most of the intended uses on your website are medical device uses. Most of these uses have not been classified and thus require pre-market approval or de novo classification, as the FDA has explained to you on numerous occasions. As part of our interactions with you, including more than 14 face-to-face and teleconference meetings, hundreds of email exchanges, and dozens of written communications, we provided you with specific feedback. However, even after these many interactions, it is now 11 months later, and you have yet to provide the FDA with any new information about these tests. You have not worked with us, did not provide the additional information we requested, and the FDA has not received any communication from 23andMe since May. Instead, we have become aware that you have initiated new marketing campaigns, including television commercials that, together with an increasing list of indications, show that you plan to expand the uses and consumer base without obtaining marketing authorization from the FDA. Therefore, 23andMe must immediately discontinue marketing until such time as it receives FDA marketing authorization for the device. Yeah, I would say youch, but this is their definition of angry? Okay. 23andMe responded to this letter by quietly pulling their ads, but they continued to sell the Ancestry product, but not the health tests. The issue with the FDA didn't seem to stop investors, though, and at this point, 23andMe started pursuing deals with drug makers to sell their accumulated genetic data to them, starting with a $10 million deal with Genentech to look at aggregated anonymous data of people with Parkinson's. And then there were deals with Pfizer and other drug companies for other data. Again, the tests were never the product. The data was the product. They also started advertising on television for their Ancestry product, again, no health tests, and they opened their own pharmaceutical laboratory. Clearly, they were not worried about the FDA. They were also not worried about a series of class action lawsuits that claimed the Ancestry results were totally meaningless. with lawyer Mark Ancorn saying that, quote, "It seems to be a very thinly disguised way of getting people to pay them to build a DNA database," unquote, which I would go further and say that it didn't just seem that way, it was definitely that. The real money was always in selling the data. But since there was no genetic counseling component, people didn't always understand what to do with the data they received. And then many of them thought the data was wrong, not just the health data, but the ancestry data as well. See, the issue is that what the company did was compare your DNA data to the data of other people who had submitted tests to 23andMe. And if you think about it, you should be able to come up with the issue about the ancestry data immediately. The people buying these tests weren't a cross-section of humanity. So, for example, there were only about 100 people of Korean descent in the database of 1.2 million people. That meant that if you were of Korean ancestry and you submitted the 23andMe saliva test, you probably weren't going to get good, useful, or accurate information about your ancestry. While some of these lawsuits got dismissed, 23andMe had arbitration provisions in their user agreements, and so in a lot of cases, the courts basically told people they couldn't sue. They had to go through arbitration instead. Eventually, one of these class action lawsuits would be settled. Class action members got an exciting $12.50 in compensation, and that was that. The insurance companies spent a lot of money trying to get out of these claims, but I don't think they were successful. The professional liability policy 23andMe bought would have been the insurance policy involved, and I know, because I actually sat next to one of the underwriters who worked on it, that the legal fight over coverage was contentious. For 23andMe's business, well, it took a couple of years of just selling ancestry products until they were able to get back up and running with the FDA. And by 2015, the company was back, selling some tests that had now been okayed by the FDA. That same year, Wohicky divorced Sergey Brin. They'd married in 2007. It was so convenient for 23andMe, I have to say. And the company really started to get into the idea of developing new pharmaceuticals, using this data they'd accumulated, and they thought they'd start their own healthcare company. As an aside, in 2015, Wohicky started dating A-Rod, Alex Rodriguez, a relationship that lasted about 2 years. And I actually debated putting this in here, but I did because I just think it's really bizarre and interesting. Because A-Rod dated Cameron Diaz before Wohicky, and his girlfriend after Wohicky was J-Lo. And apparently there was a lot of post-breakup speculation that Wohicky had broken up with him because he was not smart enough, which I got nothing. I'm just throwing it out there. It's just kind of bizarre, right? Anyway, back to the story. The FDA cleared 23andMe to start offering Parkinson's and Alzheimer's tests again in 2017, along with a bunch of other tests. And the FDA backed off in spectacular fashion from their 2013 position. And I'm highlighting this year of 2017 because I actually think it had a little bit to do with the change in government rather than 23andMe's interactions with the FDA. It's important to note, though, that the FDA said they would only approve genetic risk tests, not diagnostic tests. Eventually, 23andMe would get approval to offer more tests, including some BRCA tests. That's the test for breast cancer markers. And those tests were very important for 23andMe's bottom line. 23andMe also entered into a partnership again with a company called GlaxoSmithKline for $300 million. For that money, GSK got access to 23andMe data. That same year, 23andMe spent $400 million to buy their own telehealth company called Lemonade. And the name of this company just absolutely mystifies me. Why did they call it Lemonade? If you're going to call it a food, why would you call it that? I mean, call it like chicken soup or something. What was lemonade supposed to mean? I'm really stuck on the oddness of this name, like a lot. The next step for 23andMe, which, by the way, had still never made a profit, was, of course, to go public. 23andMe went public in 2021 with a market value of about $6 billion. At this point, they'd sold about 11 million tests. Well, I don't want to get too much in the weeds with it. They were only able to go public because of their relationship with one of Richard Branson's SPACs, SPAC entities, which if you're into finance stuff at all, using a SPAC seems to signify they were not in a great financial position before going public. There's plenty about this online if you want to read more about SPACs and why they're important and why they're a red flag. The post-IPO market value of 23andMe, that $6 billion, it didn't last very long. In 3 years, that number had dropped to 200 million. Wow. And Wohicky was trying to take the company private again by offering to buy the shares back. Where that money came from to buy those shares, I am not sure. I guess maybe from the money she made from the IPO or from other backers that she's never mentioned. She was rejected by shareholders several times. By January 2025, the company seemed to be running out of money, not a surprise, and they'd again never made a profit. There was a lot of concern that the company would be delisted from NASDAQ because the share price had dropped below $1. In March 2025, the company filed for Chapter 11 bankruptcy protection. Wohicky resigned and was replaced by a man named Joe Selsavage, who'd been part of the Lemonade team acquisition. The bankruptcy documents ignited a firestorm of concern because one of the main things 23andMe wanted to do during the bankruptcy was to, quote, facilitate a sale process to maximize the value of its business, unquote. What were they planning to sell? All of their data. With Chapter 11, the intent is always to come out of the bankruptcy as an operating company, so selling the data was an interesting choice and one that concerned a lot of people. The company also changed their name to Chrome Holding Company, which, okay, here's one thing where I wasn't able to find any data as to why they picked this particular name. At this point, Wohicky wasn't married to Sergey Brin, one of Google's founders, but to me, calling the company Chrome seems to suggest that Google was somehow involved, but I was never able to make a definite connection. I was surprised that they didn't get challenged by Google for using the word Chrome in their company name, though, and that also made me wonder. As for the sale of the data, the bankruptcy court held an auction. Now, the winner probably should have been a company called Regeneron, who offered $256 million. But amazingly, the winner offered $305 million. Who was this company? A recently founded nonprofit called TTAM Research Institute. Who founded it? Anne Wohicky. Where did the money for this come from? Not a clue. So just to recap, the founder and CEO of 23andMe, who resigned, who took an annual cash salary of something like $65,000 a year and made up the rest of her multi-million-dollar package with stock and options for 23andMe, a company now worth pennies compared to its IPO high, this person, who'd tried to buy the company several times and take it private again, somehow found $305 million to buy the data. We know Wohicky made $20 million total in salary and stock and options in 2021 and $32.5 million in 2022 and apparently nothing in 2023 and then $7.4 million in 2024. And if you add that up, you get about $60 million, which is not $305 million last time I checked. And if they didn't have a prenup, Wohicky and Brin, I would be deeply, deeply shocked. The fact of the matter is, I don't think she had this much money to spend, so I don't know where it came from, and I must say I am quite curious. I'm not a financial analyst by any means, but this does seem very bizarre to me. Where did the money come from? What is the implication of a founder buying the data? The company lost money every quarter. It was founded in 2006. That means they lost money every quarter for almost 20 years. Us insurance people can't understand that. There would be no insurance company if it lost money every quarter for 20 years. They blew through almost $1 billion in funding and deals with other companies and then buying this telehealth company. And It is true they did deals with pharma companies to give them access to the data. At some point, it seems like the pharma companies were no longer interested in paying more money for it. So it made me question, what does Wohicki think this data will do going forward? Where is the value in the data? As of today, the data sale has been finalized, and 23andMe is still in bankruptcy. I'm not sure when it will come out of bankruptcy, but I would imagine maybe by the end of this year. Did the money paid by this nonprofit for the data get dispersed to the debtors yet? Is Wohicki one of the debtors too? I mean, honestly, the thing I come back to is it just feels really hinky to me, like weird. The attorney generals in several states tried to stop the sale, but the bankruptcy court denied their appeals. What exactly does that sale mean for consumers? And how was insurance involved, and how could insurance be involved going forward? Okay, well, there are a lot of things I could talk about when it comes to insurance, because 23andMe was constantly involved in litigation, patent litigation, class action consumer litigation, and litigation against other similar companies and against various insurance companies. And almost from the beginning, this seemed to be the case, which to me personally seems a bit like a red flag. I could talk about the 23andMe class action lawsuit in 2013, claiming that ancestry and health information you receive from 23andMe is effectively useless. I could talk about 23andMe's data breach in 2023 that affected about 7 million people. I could talk about the use of DNA data in criminal investigations. You may recall that in 2018, genetic data from the Golden State Killer was linked to a relative's DNA in one of these ancestry-type databases. It wasn't 23andMe's database. And that DNA information actually led to the arrest of the Golden State Killer. On the one hand, that's amazing. And on the other hand, boy, that has some disturbing potential implications. FYI, 23andMe has always said they would not release data to law enforcement without, quote, a valid court order, subpoena, or search warrant, unquote. There are a lot of insurance things I could talk about. Today, I actually want to talk about two things. And I caution people by saying I'm only talking about the U.S. here. First thing I want to talk about is how this DNA information can be used by insurance companies legally in the U.S. and the implications for that use. My non-U.S. listeners with national health care can listen along and cringe. Second, I want to talk about the sale of the information in the bankruptcy proceedings and what it might be used for outside of the insurance industry, using the 2023 data breach as an example of what might happen. I mentioned earlier that in 2008, Congress passed something called GINA, or the Genetic Information Non-Disclosure Act. Now, in theory, this act is supposed to prevent the use of genetic information in employment or health insurance. So, if, say, you got a BRCA test for breast cancer markers and it came up positive, your health insurer could not punish you for that with higher rates, and they couldn't call it a pre-existing condition. Just having the BRCA marker does not make it 100% certain you will get breast cancer. And your employer couldn't fire you or decide not to hire you because of it. And that's a good thing for a lot of obvious reasons. However, GINA has a lot of loopholes, and one of those is for companies that sell long-term care insurance. This is insurance you might buy to cover a stay in a nursing home, an Alzheimer's facility, or a similar care situation. Long-term care insurance is one of those things most people don't want to think about. I saw a statistic that only about 10% of people over 50 have long-term care insurance. Those people that do have it complain about cost and coverage, and the companies that sell it are struggling. My understanding is that the insurance companies and their actuaries figured that a person going into long-term care would only be there for a few months before they got better or they passed away. But that has turned out not to be the case. People live longer with serious disease, and when you estimate the average potential costs in a long-term care facility as 3 to 6 months for any one person, and the actual cost is something like 2 to 5 years for the majority of people, well, that is not a sustainable model for an insurance company to stay afloat. It doesn't help that long-term care is crazy expensive. Think $10,000 per month for a private room in a nursing home, not even a fancy nursing home. Considering how underpaid most people working in long-term care are, this is one of those things that I am sure it is complicated, but someone's getting paid in the end, and I wish it was people doing the actual work with human beings. For consumers in the U.S., your health insurance does not generally cover this type of care, and Medicare doesn't cover a lot of it either. If you don't have long-term care insurance, you'll be paying out of pocket, or your family will be paying for you. Even with long-term care, you're still paying a good chunk. And I can't say whether or not it makes sense for you, but you might want to look into it. Long-term care insurance companies are struggling because they are paying out more than expected. And as a result, long-term care companies would really, really, really like to see your genetic information to decide whether they should cover you and how much they might charge if they do. In my opinion, they should not be able to use this information. It penalizes people who do the testing as opposed to people who do not. Both people could have the same markers for disease, but the one who doesn't do the testing will have a better result with the long-term care company's underwriting, all other things being equal. And taking that a step further, requiring genetic testing for long-term care is not a road we want to go down because, again, these tests are not certain indications that you will get a disease. Some states have taken it upon themselves to pass additional state laws restricting the use of genetic information in long-term care insurance. You can research that online if you're curious. But if you do have testing and you apply for long-term care insurance, you're probably going to have to disclose it. Not disclosing it could lead to a claim being denied. And they do get to see your medical records in the underwriting process anyway, so if you've mentioned it to your doctor, then it will be something that they would be able to see. The other loophole that Gina does not apply to is life insurance. Again, some states have prohibited the use of genetic testing in life insurance applications, so you'd have to check your specific state laws. My gut underwriting sense is that the issue of genetic testing is less of a problem with life insurance because this is an industry with a tremendous amount of data, and I suspect adding in genetic data wouldn't tip the scales. It would just be another consideration in the thousands of considerations that actuaries take when building mortality tables. And actually, as I was thinking about this, taking the data from life insurance companies and combining it with the data from genetic testing could be really interesting from a statistics standpoint. I'm just wondering if the aggregate of that data over time could actually better inform the chances of someone with a genetic marker actually getting and dying of a particular disease. And I wonder how that would compare of, say, a medical study with the same cohort. I'm just spitballing here, but I think there's some really interesting opportunities. I do think for consumers, they should not be as concerned. The final thing I will say about Gina is that it only applies to companies with more than 15 employees. Most businesses in the U.S. are small businesses, and most of them have less than 15 employees. So keep that in mind. The Genetic Non-Discrimination Act does not apply. That's a loophole I'd really like them to close. The other issue I want to talk about today is the sold data. First, whenever 23andMe shared data with their pharmaceutical partners, it was always aggregated and anonymized. What that means is that you could not identify an individual from that data. That's a good thing. The data that's being sold in bankruptcy is all of the data, all of the information on 15 million people. As I mentioned briefly, in 2023, there was a data breach at 23andMe that affected about 7 million people. The insurance companies insuring 23andMe, the cyber insurance policies, paid almost all of that $30 million settlement that would be shared among those people affected. And the insurance also paid for the 5 years of data monitoring that would accompany that settlement. Most people in the settlement will probably only get about $165 in compensation. Whoopee. When people signed up for 23andMe, they had to agree to share their data with 23andMe. And in response, 23andMe agreed not to share that data without their express consent. The fact is, most people don't read those releases, and most people just checked the consent box without really thinking too much about it. But depending on the year a person signed up for 23andMe, the consent letter was different. And many people signed consent letters that did not mention what might happen to their data in the case of 23andMe's bankruptcy. And this is part of the problem. 23andMe, through the bankruptcy court, could sell that data to literally anyone for any purpose. Even if you say that the new buyer has to hold to the 23andMe privacy and consent standards, if they petitioned their customers to change it, or even if the new nonprofit sends you an email petitioning to change it, would people get that email, and would they know it was important? And would they understand what they were checking, or would they just check it without reading the wall of disclaimers and texts? And further than that, would the new entity buying the data have the same security promises as 23andMe? Could they change them after the sale went through? You may not know this, but 23andMe is not subject to HIPAA because they're not a medical provider by that definition. So they're actually only subject to less stringent privacy laws. And then, of course, what they as a company have decided to implement in regards to privacy practices. The bankruptcy court weighed in on these issues, and specifically, they said that the new buyer was, quote, legally obligated to maintain and honor 23andMe's existing privacy policies, user consents, and data protection measures, unquote. But they're not required to ask people whether they're okay with this new company buying their information. They're also not required to ask people what should be done with the information of people who have died. And there's nothing about whether or not the new owner of the info can sell or transfer the data they have purchased in some future transaction. That's a problem. During a congressional hearing this year, Margaret Hu, a law professor, also brought up the fact that 23andMe had laid off about half of their staff and implied that data protection employees may also have been part of that layoff, which raises the question as to whether they are doing the things at 23andMe that they need to do if they have the employees to do the things they need to do to keep the data safe. We don't know what kinds of systems are in place at TTAM, the nonprofit that bought the data, for that data. Who is protecting the data when the lights are being turned off at a company? Or who is protecting the data when, in the case of this nonprofit, the lights are being turned on? Is this company prepared to keep the data safe? What was clear from the 2023 data breach was that there were people looking to get very specific data on certain populations. The info in the breach included names, ancestry reports, family tree information, health information, and raw genetic data. There were 7 million people affected, but based on what was investigated and the data that was sold on the dark web, that suggested some really nefarious things, because most of the data offered up for sale involved customers of either Chinese or Ashkenazi Jewish ancestry. Remember how I mentioned in the beginning that the Chinese government is one of the entities that has the most genetic data on people? It makes you wonder why Chinese data in 23andMe was targeted. If law enforcement could use a DNA sample of the Golden State Killer to then find a distant relative and then find the Golden State Killer, what's to say that, for example, China wouldn't use that information to find a distant relative in the U.S. of a dissident living in China under another name? And that was just the very first scenario that came to mind. And what would the data on people with Ashkenazi ancestry be used for? I cannot imagine anything good. The law professor testifying in front of Congress also highlighted some really terrifying things that could be done with the data, either via a data breach or if it was sold in the future, including using that information for state biometric and cyber surveillance, data used by foreign actors against U.S. service members, and the targeting of individuals online. I'll throw in the sale of the data to U.S. law enforcement where it could be used in prosecution. I am sure in our current political climate in the U.S. that you can probably think of a few other ways that the data could be used, and all of them are awful. While the nonprofit promised as part of the sale agreement to continue the privacy guidelines that 23andMe used, I don't think it's a long shot that they might change their mind in the future and then send out a dense user agreement with different wording and get a lot of people to sign off on their data being sold without really understanding who was buying it and what it would be used for. The unknowables about how the sold data will be used in the future is the reason why, after 23andMe filed for bankruptcy and indicated they would sell their data to an outside company, so many state attorney generals and safety specialists told people to go into 23andMe and delete their DNA and genetic information. And I personally would suggest that you follow their advice and do the same if you have registered and submitted DNA samples to 23andMe or, frankly, to any company that does this sort of thing. I think that while the idea of learning about your ancestry and maybe finding some lost relatives and understanding your health factors is something a lot of people want to do, I think the uncertainty about how the data will be used in the future is something that is too problematic. I mean, back to that Margaret Atwood quote, we know the thing we expect, you learn more about yourself. But as to the things we don't expect and the dumb things we never expected, well, I don't mean to be a downer, but again, it's your choice. But I know where I'd fall. One of the questions I had when I started researching this is whether or not something like 23andMe, a company that markets directly to consumers, selling genetic data information, should even exist at all. And if it should exist, who should be able to run such a company and how should it be restricted? I don't know the answer to that. I do think genetic testing should exist. It's done a tremendous amount of good, but I kind of think it should remain within the confines of the medical profession, as in you have to get it through your doctor, and then you have to get the genetic counseling afterwards to better understand your results and your options. Ancestry testing is fascinating, and while I haven't done it myself, I have family members and friends who have learned a lot from it, sometimes things they didn't necessarily want to know, although after this episode, I do kind of doubt the results for some things. The fact is that legally, the laws in the U.S. are not in place to protect us the way that they should, and until that changes, I would say you should tread very carefully. In the insurance versus history standoff, I actually think I've changed my mind. I'm going to call this a tie, but nobody wins. Insurance paid on the data breach in 2023 and then on some other things as well. And while genetic data might be useful in underwriting, the ethics of it are troubling enough that I just don't think it should be allowed. On the other hand, I must admit, I'm a little worried about history here because let's hope this data is never used for nefarious means. Thanks again for listening. I hope you learned something, and if you are registered with one of these genetic testing companies, I would encourage you to download your information and then follow the necessary steps to revoke your consent for that data to be used and then delete that data entirely. There are a lot of ways you can do that, and your best bet right now is to do a quick online search for the database in question and limit the search to this year so you have the most up-to-date data about how to do it. Please take a second to rate and review the podcast so that other people can find it, and make sure you're subscribed if you aren't already. You can support the podcast by hiring me to come speak to your meeting or organization about a topic of your choice or about insurance history and why insurance matters. You can also donate to my Buy Me a Coffee fund at buymeacoffee.com/InsuranceVSHIST. That money goes right back into production cost. I love to hear from listeners, and you can reach me either through LinkedIn or directly via email at meredith@insuranceversushistory.com. The next episode will be slightly shorter, and I am open to suggestions. What do you want me to talk about? Email me or comment on my LinkedIn, and if I pick your topic for the next episode of Insurance versus History, I will give you a shout out. And as always, be safe, be smart, and read your policy wording. Boy, that's a hard word to say, anonymized.